The Supreme Court has denied a stay that would have protected a state's Second Amendment sanctuary law. This law bars a state agent from enforcing federal laws which violate the Second Amendment, and now the Eighth Circuit is refusing also to take action. So let's talk about what is happening. But really quick, before we jump into this video, I want to ask you guys for a huge favor. I was looking at some of my analytics, and about 60% of all viewers here on the channel are actually not subscribed to the channel. So if you guys enjoy this 2A content, if you want to support the channel, one of the best ways to do that is actually subscribing. And also just double check because YouTube unsubscribes people all the time. But regardless, thank you guys so much for all of your support. And thank you to everybody that subscribes and supports the channel. As I mentioned in the intro, in this video, we're going to be talking about an 8-1 order that was issued by the United States Supreme Court and how it impacts a state's Second Amendment sanctuary law. The recent Supreme Court order denied a stay which would have protected Missouri's Second Amendment Preservation Act, but the state is still fighting back, but the Eighth Circuit is not actually cooperating. In 2021, Missouri passed a law which is the Second Amendment Preservation Act. The law set the state's interpretation of the Second Amendment and set restrictions on the enforcement of inconsistent federal laws. This law in question prohibits Missouri's officers, agents, and government officials from helping federal agents who are attempting to enforce inconsistent federal laws. The law we're talking about uses the 10th Amendment as a basis to refuse state resources that would then be used by federal agents to infringe on Second Amendment rights. The law also created a civil remedy where anyone could sue a Missouri official, an officer, or an agent if they help to enforce a federal law that does in fact violate the Second Amendment. Now, in response to this Second Amendment sanctuary law in Missouri, the United States government sued Missouri, and recently the United States Supreme Court got involved in this case and an 8-1 order denied a stay which would have allowed the state law to continue to be enforced and remain in place. But the United States Supreme Court issued an 8-1 order denying that protection. Now, in this case, the US government sued Missouri under the theory that the law is unconstitutional because the statute is premised on an incorrect interpretation of the Second Amendment. Essentially, the government here argues that Missouri's super pro-Second Amendment law is unconstitutional and that the government's more limited interpretation of the Second Amendment is correct instead. The District Court on review agreed and struck down that law in its entirety. The District Court issued an injunction preventing the state of Missouri and its agents from enforcing the law. Now, one of the critical components of this law and how it's structured is the fact that there are civil remedies that any resident in Missouri can bring against any other person or an officer or agent who violates this statute. So essentially, a private individual can sue an officer and agent under this language and say that they violated the Second Amendment, they violated this law, and therefore hold them accountable. Now, there are other things attached to this, like civil penalties that are fined, $50,000 per employee that it's hired by that law enforcement agency, for example, that helps to enforce or aid in that violation of the Second Amendment. So there are these civil remedy components that are also tied to this specific law and bill in question. This Missouri law is similar to what Texas did in their Texas abortion law and also the recent Supreme Court decision in Whole Women's Health. That fact is also important for why the Whole Women's Health case in that decision was referenced by Justice Alito in that recent 8-1 order in this case. If you're not aware, the Texas abortion law, or SB 8, prohibits an abortion if a fetal heartbeat is present. This law is different from other laws because it's not enforced by the state or Texas or any of its officers or agents. Instead, it allows an individual to sue any other individual who performs or knowingly aids and abets in that activity. This means that the enforcement mechanism is not given to the state or any of its officers or agents, but instead any person who wants to sue to stop that conduct can sue under this law. So again, the enforcement mechanism and the enforcement power is not in the government or the state, but it's given to the people. Now, here's where things become very relevant for what Missouri is doing with this Second Amendment Preservation Act and the recent Supreme Court denial, which was issued. SB 8 shielded Texas and its officers and agents from lawsuits, since that statute allows only individuals to bring a lawsuit, not the state or any of its officers. The enforcement mechanism of the law was designed in order to make it harder, if not impossible, to get this entire law struck down. This is because courts don't actually strike down laws. What they do is place injunctions or enjoin a type of enforcement of a law. So, for example, a court can enjoin this Missouri Attorney General from enforcing the law, and as a result of that injunction, it essentially nullifies that law, so the law is nullified. But with SB 8, and this scheme here in Missouri, the umbrella injunction against a state or attorney general is almost useless because, again, like I mentioned, they're not the ones enforcing the law. Instead, you would have to get an injunction against each individual, private individual who is suing on behalf of the language in the law. But you could get an injunction against one person, but then a different person, a different private individual bring a lawsuit. Then you would have to get an injunction against that same person, that different person as well. And then just on and on. Every time a lawsuit would pop up, you would have to get an injunction against that new person. But there would be no way to get an umbrella injunction against the entire enforcement of the law. Now, this SB 8 issue made its way up to the United States Supreme Court in the Whole Women's Health versus Jackson case. The Supreme Court found that since SB 8 is not enforced by the state or its agents, then you cannot seek an injunction against those individuals. You also could not even get an injunction against the judge who hears one of these lawsuits, or even the clerks in question, which were part of that SB 8 lawsuit. Instead, you would have to get an injunction against each and every citizen and each and every plaintiff who sued on behalf of that law. So that's kind of some of the backdrop and some of the legal ramifications of what's going on with the Missouri 2A Preservation Act and kind of the interplay between SB 8, prior Supreme Court decisions in the Whole Women's Health case, and now what is happening with this recent 8-1 order. Now, originally in this case, the District Court on review struck down the entire Missouri law and enjoined the state of Missouri and its officials from enforcing it. But again, here's the issue. None of them are actually enforcing it anyways. The people do. Missouri then appealed the decision up to the 8th Circuit and also asked for a stay of the decision while the appeal is taking place. However, the 8th Circuit denied that request for a stay. That then led Missouri to file an emergency application up to the United States Supreme Court, and they were asking for the Supreme Court to grant a stay pending the appeal. And recently, we got an order from the United States Supreme Court, which ultimately denied that request for a stay. The order states that the application for stay presented to Justice Kavanaugh and by him referred to the court is denied. Justice Thomas would grant the application for stay. So Justice Thomas was the only one who would have granted the stay, and so that was an 8-1 denial order that was issued by the Supreme Court. Now, there were some additional statements made by Justice Gorsuch and Justice Alito, which shined a little extra light on what actually is happening with them denying this stay. And this is what these two Justices, Gorsuch and Alito, said. With the understanding that the District Court prohibited only implementation and enforcement of HB 85 by the state of Missouri and its officers, agents, and employees, and any others in active concert with such individuals, I agree with the denial of the application for a stay under the present circumstances. An injunction purporting to bind private parties not before the District Court or the challenge provisions themselves, however, would be inconsistent with the equitable powers of federal courts. And then there, they cite the Whole Women's Health case. So essentially, the Supreme Court denied the stay, and the state is enjoined. But like I mentioned, it doesn't really stop the law in any way from actually being enforced because, like I said, the police officers or the state officials or anyone in question aren't actually the ones, who have the enforcement mechanism. It's actually the people, and private parties can still sue them if they engage in conduct that is prohibited under this law. Now, even after this order, the state of Missouri responded very quick. They filed for expedited review in this case. They went back to the 8th Circuit, asked for expedited review because of the Supreme Court's recent denial, and both sides agreed to expedited review in this case for expedited oral arguments and briefing, and actually the 8th Circuit agreed, and they set this to be calendared and argued on an expedited basis. Recently, the 8th Circuit issued an order agreeing that the case needed expedited review. Then the 8th Circuit issued an order stating that the oral arguments would take place in this case on February 16th. But then suddenly, out of nowhere, we received an interesting order from the 8th Circuit. It states that, on the court's own motion, this case has been removed from the February calendar. Counsel need not appear for argument on Friday, February 16th, 2024. Counsel will be notified when the case is set on a future calendar. Now, what does this mean? Well, it means that the 8th Circuit randomly on their own this week, pretty much like a week and a half before the arguments were set to take place in the 8th Circuit, which is significant, suddenly they decided to remove the case from the calendar, remove the oral arguments, push it out to a future unknown time, and say, hey, we're removing this from our calendar, we're doing this on our own, and we'll let you know when we are picking a new date. In some ways, it's kind of strange and maybe concerning for the future outcome of this case. It's very interesting that they said, yes, we agree for expedited review. Everyone was set to go to oral arguments. And then suddenly on the court's own motion, they said, Psych, never mind, we're removing this from the calendar. So definitely a very interesting case. Now we're definitely be keeping our eyes on even more. If you guys have any questions, go ahead and comment down below and I will try to answer the best of my ability. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.